At 2:47 in the morning, the Supreme Court of the United States issued an emergency order, not a scheduled opinion, not a ruling handed down on a normal Tuesday morning with cameras ready and reporters in position. An emergency order. In the middle of the night, signed by 7 of 9 justices, crossing ideological lines that have not crossed on anything in years. By the time most Americans woke up and checked their phones, the legal architecture of this country had already changed. I want to be precise about that phrase. Changed. Not shifted slightly. Not nudged in a new direction. The mechanism that both political parties have used for decades to win policy fights they could not win through elections. The mechanism that has shaped immigration law, gun law, environmental law, election law, and healthcare policy across your entire adult life was just declared constitutionally illegitimate by a 7-2 supermajority of the highest court in the land. And if that is not leading every broadcast you watch and filling every front page you read, that absence tells you something important about the institutions that are supposed to keep you informed. Here is what actually happened, why it matters more than almost anything else that has occurred in American law in the last decade, and, most importantly, exactly what it means for the policies that govern your daily life, starting right now. To understand why 7 justices acted with the kind of urgency that produces a 3 a.m. emergency order, you have to understand the weapon they were trying to dismantle. And to understand the weapon, you have to go back to how it was built. It starts with a legitimate legal concept. When a court rules in your favor, it can issue an injunction, an order requiring someone to stop doing something harmful to you. If a company is dumping chemicals into your water supply and you sue, a court can order them to stop while the case proceeds. That is injunctive relief functioning exactly as it was designed, proportional, targeted, protecting the specific people who were actually harmed. Now here is where it breaks. At some point, legal historians will debate exactly when, but it accelerated sharply in the 1990s and exploded after 2015. Federal judges began issuing injunctions that did not just protect the plaintiffs in front of them. They issued injunctions that froze federal laws and executive policies for the entire country, all 330 million people. Based on a lawsuit filed by a handful of plaintiffs in a single courthouse in a single city. The legal term is nationwide injunction. The political term, if anyone in Washington were being honest, is a veto by geography. Here is how the game worked in practice, because it was absolutely a game, played deliberately by sophisticated legal teams who knew exactly what they were doing. Your side loses in Congress. The votes are not there. The democratic process produced an outcome you did not want. A generation ago, that meant you went back to your constituents. You built a broader coalition. You did the grinding work of persuasion, and you tried again. Instead, starting around 2 decades ago, you called your legal team. Your legal team identified a federal judge, not just any federal judge, the right federal judge, sitting in a jurisdiction where the political and judicial winds already blew your direction. You filed your lawsuit there, and you asked that one judge to freeze the law or policy you opposed for the entire country while the case proceeded. If you were a conservative legal team, you knew which district courts in Texas and Florida were most likely to issue the broad injunctions you needed. If you were a progressive legal team, you knew which courts in California and the Pacific Northwest were most reliably sympathetic. The practice was so normalized, so institutionalized, that major advocacy organizations had it built into their standard legal strategy documents. You did not need to win elections to stop a law. You needed to win a courthouse lottery. And the consequences of that system, allowed to compound over 20 years, are what 7 Supreme Court justices decided they could no longer ignore. I want to give you specific examples, because this story is often told in abstractions, and abstractions let people tune out. The Trump administration's travel ban in 2017. A federal district judge in Hawaii, a state with a population of 1.4 million people, roughly 0.4% of the country, issued a nationwide injunction that froze a presidential executive order affecting immigration policy across all 50 states. One judge, one courthouse, one order, national effect. The Obama administration's DACA program in 2021. A federal judge in Texas issued a nationwide injunction blocking the program that protected approximately 600,000 people from deportation, based on a lawsuit brought by the state of Texas. one judge, one order, 600,000 lives in legal limbo nationwide. Biden-era student loan relief in 2022. A federal judge in Missouri blocked a debt relief program affecting 43 million borrowers nationwide based on a lawsuit brought by 6 states. The borrowers who would have been relieved were not parties to the case. They had no voice in the courthouse where their fate was decided. One judge, one order, 43 million people. Environmental regulations, gun laws, vaccine mandates, voting rules. In every single one of these policy arenas, both parties ran the same play. File in the right court, get the right judge, freeze the policy nationally. The side that lost in the legislature tried to win in the courthouse. And the courthouse, again and again, obliged. What the Supreme Court saw when it looked at this pattern was not a legal system functioning as designed. It was a legal system that had been converted, gradually and deliberately, into a parallel legislature, one where the democratic process was optional, and geographic luck determined national outcomes. 7 justices decided that had to stop. The Supreme Court's emergency order zeroed in on a legal concept called scope of injunctive relief. In plain English, when a court rules in your favor, how far does that ruling actually reach? The answer the court delivered, by a 7-2 margin that crossed every ideological line that has defined this court for years, is that injunctive relief must be proportional to the actual injury suffered by the actual people who brought the actual case. If you are harmed, a court can protect you. A court cannot use your harm as a legal lever to impose its policy preferences on 330 million people who were not in the room. Justice Neil Gorsuch wrote a concurring opinion, meaning he agreed with the majority but felt the moment required him to say something additional on the record. And the language he chose is already being treated as one of the defining legal statements of this decade. He wrote that lower federal courts issuing these broad nationwide injunctions have been acting as mini legislators. Sit with that for a moment. A sitting Supreme Court justice looked at the accumulated behavior of federal district courts across this country and wrote, formally, on the record, in a document that will be cited in courtrooms for generations, that they have not been functioning as judges. They have been functioning as unelected lawmakers, accountable to no voter, imposing national policy based on lawsuits brought by small groups of plaintiffs in carefully selected jurisdictions. Gorsuch went further. He argued that courts must return to what he called the traditional limits of equitable relief, the foundational legal principle that a remedy must match the injury. The remedy for harm done to 10 plaintiffs in Hawaii is not a national policy freeze affecting 330 million Americans. Those are not proportional. And a justice system built on disproportion is not a justice system. It is a policy machine wearing judicial robes. The dissent came from Justices Sonia Sotomayor and Ketanji Brown Jackson, and their concern is real and deserves honest engagement rather than dismissal. Sotomayor warned that restricting nationwide injunctions creates a patchwork legal reality. If courts can only protect the specific plaintiffs who sued, you end up in a country where the same federal law is enforceable in Georgia and blocked in California, where your legal rights depend not on the Constitution, but on whether you or someone like you happen to be a party to a lawsuit filed in the right courthouse at the right time. That is a legitimate concern about legal equality, and it should be taken seriously. But here is why the majority was not persuaded, and why, even acknowledging the turbulence ahead, 7 justices concluded that the alternative was worse.
The system Sotomayor is warning about losing, the nationwide injunction system, did not produce legal equality. It produced a different and arguably more dangerous form of inequality. An inequality determined by which side had better lawyers, better courthouse geography, and better luck in the judicial lottery. An inequality that had been systematically exploited for decades by every well-funded interest group that figured out how to win without governing. If Congress needs to build more consistent legal frameworks to prevent the chaos she is warning about, and it does, and it should, then Congress needs to do exactly that. Through elections, through legislation, through the democratic process the Constitution actually established. The answer to broken democratic institutions is not to permanently hand their power to unelected judges. It is to fix the democratic institutions. This is the section that matters most, and the section that most coverage of this ruling skips past too quickly. Abstract constitutional law is important, but what does this ruling mean for the policies that govern your actual daily existence? Let's go through it directly. Immigration. Immigration has been the single most injunction-saturated policy arena in American law for the last decade. Every major immigration action by every administration has been frozen, unfrozen, refrozen, and challenged through nationwide injunctions. The Trump travel bans, Biden's enforcement priorities, DACA, border policy, asylum rules. The pattern was so consistent that immigration lawyers on both sides of every debate built their strategies around it. You did not need to win the policy argument. You needed to win the injunction. Under the framework the Supreme Court just established, a single district court in a favorable jurisdiction can no longer freeze the entire national immigration system based on a lawsuit brought by one state or one advocacy group. The injunction can protect the specific plaintiffs. It cannot rewrite national immigration policy. For supporters of stricter enforcement, federal immigration authorities now have significantly more operational latitude while legal challenges work through the courts. For supporters of broader protections, the tool that has repeatedly been used to freeze enforcement sweeps is now substantially curtailed. Both sides just lost their most powerful judicial shortcut simultaneously. Guns. Multiple states passed significant gun regulations over the last several years. Red flag laws, background check expansions, assault weapons restrictions, high-capacity magazine bans. In nearly every case, the laws were challenged immediately, and in several cases frozen by nationwide injunctions before they ever had a real operational effect. Under the new framework, a state that passes a gun law has dramatically more runway to actually enforce it, while legal challenges proceed through the proper appellate process. A district court judge in a gun-friendly jurisdiction can no longer issue a national block on a law passed by a different state's legislature based on a lawsuit brought by plaintiffs who do not live there. Whether you support those gun laws or oppose them, the mechanism for stopping them before they function just became dramatically less accessible. That is a concrete, immediate change in how gun policy operates across America. Elections. Election law has been perhaps the most consequential arena for injunctive warfare in American history. Voter ID laws, absentee ballot rules, redistricting maps, early voting windows, drop box regulations. Every major election law fight in the last decade has involved at least one side running to federal court to get a national block. The ruling makes it dramatically harder to use a single lawsuit in a single jurisdiction to freeze election rules nationwide. Election policy, how you vote, who counts your ballot, what your ballot looks like, how long polls stay open, is going to have to be determined through state legislatures and through Congress, through the actual democratic processes the Constitution established, not through which side reached the right federal judge first. That is slower, it is messier, it will produce outcomes that frustrate people across the entire political spectrum. It is also the correct process. The environment. Environmental regulation has been one of the most active injunctive battlegrounds in American legal history. The Clean Power Plan, methane emissions rules, clean water regulations, endangered species protections. At various points, every one of these policies has been frozen by a nationwide injunction issued by a single district court judge, halting national environmental policy based on a lawsuit brought by a handful of states or industry groups. That tool just became dramatically less available. If you have been relying on federal courts to defend environmental protections that Congress will not pass through legislation, this ruling is a direct blow to that strategy. The battleground just shifted from courtrooms to legislatures. Environmental advocates who want durable, enforceable protections now need to win elections and pass laws. A favorable injunction from a sympathetic judge was never a substitute for democratic mandate. After this ruling, it is even less of one. Healthcare. The Affordable Care Act was challenged through nationwide injunctions multiple times. Contraception coverage mandates, Medicaid expansion rules, drug pricing regulations, all of them frozen at various points by district court judges before the merits were ever fully adjudicated. The same shift applies here. Healthcare policy that was previously vulnerable to being frozen nationally by a single sympathetic judge now has significantly more protection from that kind of judicial veto, regardless of which direction the policy runs. The political reaction to this ruling started within hours of the order being published, and it has been revealing. The White House released a statement that legal analysts described almost universally as deliberately non-committal. Language about reviewing the court's order. Language engineered to say nothing while appearing to say something. That is the language of an institution that took a significant hit and is calculating how to manage the damage without acknowledging its severity. Inside the Department of Justice, multiple sources using the same word to describe the ruling: earthquake. Because that is what it is for an agency that has spent years treating district court injunctions as a substitute for legislative action, using favorable rulings to implement policy that could not survive the democratic process. That playbook just got torn up. State attorneys general moved with a speed that tells you they were prepared. Within hours, AGs from multiple states had filed supplemental legal briefs in ongoing cases, citing the Supreme Court decision directly. Legal teams that had been watching this moment build for years deployed the ruling the instant it arrived. And here is the political reality that deserves to be stated plainly, because the partisan framing of this ruling is already starting, and it is already dishonest. This ruling does not help one party. This ruling does not advantage one ideology. In this specific moment in 2026, with the current configuration of power in Washington, the states most energized by this decision tend to be Republican-led states fighting federal policies. But that dynamic is not fixed. It is entirely contingent on who holds the White House. When Democrats controlled the executive branch, it was Republican attorneys general using nationwide injunctions to freeze progressive policies. When Republicans control the executive branch, it is Democratic attorneys general using the same tool to freeze conservative policies. Both sides screamed about judicial overreach when the other team held the injunction. Both sides celebrated it when their team did. 7 justices just looked at all of them and said, "Stop, both of you. This is not what courts are for." This was an emergency ruling, not a final, comprehensive opinion resolving every question it raises. The legal recalibration that begins now will take years to fully work through the system. Lower courts will now have to apply the new, narrower framework to existing disputes, and they will do so knowing the Supreme Court is watching. Issuing a sweeping nationwide injunction without rigorous, specific, constitutionally grounded justification now carries the near certainty of rapid reversal from above. The federal government will push back. It will identify cases where it can argue the national interest is so compelling that broader relief is warranted even under the new standard. There will be test cases. There will be circuit court splits where different appellate courts interpret the standard differently. Those splits will eventually force the Supreme Court back for a full merits decision with a comprehensive written opinion. This is the beginning of a multi-year legal recalibration. Not the end of the fight, but what cannot be walked back is the formal declaration issued by 7 justices, crossing ideological lines, in an emergency order that will be cited in every federal courtroom in America, that using nationwide injunctions as a political shortcut is constitutionally illegitimate. That declaration changes how lawyers advise clients today. It changes how advocacy organizations structure legal strategies today. It changes how federal agencies calculate risk when issuing new rules today. The entire calculus of American legal strategy shifted the moment that order was published. There is a deeper implication that deserves to be said without softening. For decades, both political parties have been quietly comfortable allowing federal courts to accumulate power they were never constitutionally meant to have. Because it was convenient, because it meant you could win without governing. You could achieve national policy outcomes without winning Congress, without winning state legislatures, without doing the exhausting and unglamorous work of actually persuading your fellow citizens that your ideas deserved to prevail. You could just find the right judge. 7 justices of the Supreme Court just closed that door. And what that means, whether you love this ruling or fear it, is that American democracy is about to be required to function more like an actual democracy. If you want change, you have to win elections. You have to pass laws. You have to build coalitions. You have to govern. A favorable injunction is not a mandate. A sympathetic judge is not a democratic consensus. Courts cannot be a substitute for political legitimacy, and 7 justices just put that principle back at the center of American constitutional law. That is harder. It is slower. It will produce outcomes that frustrate every side of every debate. It will require more from citizens who have been allowed for too long to outsource their political responsibilities to lawyers in federal courtrooms. But it is the system the Constitution actually created. And on the night of June 25, 2026, at 2:47 in the morning, 7 justices decided this country needed to be reminded of that.